morning, everyone. Hope you're doing well and that your Stewards Council is well underway. Good to see some familiar faces and good to see some new faces around the table as well. As Ian's mentioned, I'm here today and I've been asked to come in and give you a bit of an update on some of the issues that our office has been working on and following over the last year. And so I've selected a few things, and at the end of the presentation, of course, if there are questions about matters that haven't been discussed, or if you want more information on what's up here, feel free to come up to the mic and put your questions. The first thing of interest, and I raise this because this has been a long time coming, is our constitutional challenge on the Expenditure Restraint Act. You'll remember that back in 2008, when the government introduced wage restraint legislation, it had the effect of imposing a limit on the economic increases that could be negotiated at the bargaining table. And for some groups, it even had the effect of rolling back wages or wage increases that had been negotiated in collective agreements. And so the Institute launched a challenge alleging that that legislation, from the government, was a violation of the freedom of association, which includes the right to the process of collective bargaining now. The Institute wasn't the only one to launch this challenge against this particular piece of legislation. There were challenges brought by a group of employees at the RCMP. In that case, it's called the Meredith versus RCMP case. As you might recall, at the RCMP, there is no right to form a union per se, and that's a matter that is going to the Supreme Court in itself. But the association of employees that had formed for the purpose of bargaining had reached an agreement, and the wage restraint legislation had the effect of rolling back and taking away things that had been agreed upon. So Mr. Meredith and his colleagues on the Pay Council challenged the legislation at the federal court. They were successful at the federal court. They were overturned at the Court of Appeal. And the Supreme Court has just, in the last 2 weeks, decided that it was going to hear that appeal at the Supreme Court. So that's an interesting twist to this case. Our own arguments are going to be made at the Ontario Superior Court the week of October 21st, and that will be the first time that our case is heard. There has been a failed attempt to get to the Supreme Court by a fellow union, the AJC, Association of Justice Council. They had brought the same challenge, different facts of course, but the same challenge to the Ontario Court. And they were partially successful in that the retroactive aspect of the legislation, so just to bring you back, in 2008, the government decided it was going to freeze economic increases, not just moving forward, but also going back to the years 2006 and 2007. So in the AJC decision, the Ontario Court decided that that was a violation of charter rights that wasn't justified by the dire economic circumstances that the government has argued existed. The government appealed that, and unfortunately, the Court of Appeal overturned the Ontario Court's decision in a terrible piece of jurisprudence. The AJC sought leave to appeal to the Supreme Court, and they were denied. So it's quite interesting that the Meredith case, which brings up some different facts, is going to be heard by the Supreme Court. There's also a case out west, the BC dockyard workers. That case led to a pretty bad decision from the BC Superior Court, was heard on appeal, and we're waiting for the decision on that one. So this legislation has been challenged across the country in 4 different courts, has led to 4 different results. And the Institute's challenge, the one advantage that we have coming at the end of these different pieces of legal battles, is that we've seen what's worked better and what's not worked so well in terms of the arguments that were put forward. We also present, because of the multitude of groups and the different parts that they were at in their collective bargaining, we bring in pieces of each of those 4 cases mixed together. So we have the broadest fact situation of all of these cases moving forward. We have Crown corporations. There was a case in Quebec that was very successful, contesting the ERA that we're going to draw on. We've also been able to retain an economist to really put to task the government's evidence about how dire the economic circumstances really were back in 2006. And that's an aspect that's not been argued before in any of the cases that have come before. So we're still, actually, I'm a little bit late getting here because we're working on finalizing our last written arguments to the court. As I say, that's heading up for a hearing in October. And so you'll want to see what happens. Of course, the court's not expected to give its decision right away, so still some more waiting involved there. There you go. You may have heard, this is not a case that we're directly involved in, but it certainly affects the institute and collective bargaining in the federal public sector at large. Very recently, the federal court set aside the Minister of the Treasury Board's decision to order a vote on the employer's last offer in the case of the CBSA border services officers. It was the first time that that power of the ministers was used under the PSLRA, and the Alliance, which is the bargaining agent involved in this litigation representing the border services guards, brought this matter to the federal court and argued a number of things, and they were successful with one of them. And that's the part that the minister, in making his decision to order a vote, so in practice what happened is that the minister wrote to the chair of the PSLRB and said, here was our last offer in collective bargaining. We are ordering you to put this offer to a vote of the membership who is entitled to vote on a collective agreement immediately. The Alliance argued that in getting to that point, the minister had not sought out the view of the bargaining agent and only of the employer representatives. And so the court took the position that there had been no procedural fairness in the minister arriving to his decision, that he at the very least had an obligation to seek out the views of both the employer and the bargaining agent in arriving at his decision. So that decision was overturned, and as of yet, the government hasn't appealed. That may be because they plan on simply, turning back the clock, getting the views of the Alliance, getting the views of the employer, and then imposing the vote. Who knows where it will lead, but they still have a few days left to seek an appeal of that decision, which I wouldn't be surprised if they did appeal it, because it kind of sets a pretty interesting precedent in terms of the collective bargaining process. And even when there's a discretion involved, in this case it was the minister's discretion that's being questioned, even in those circumstances, the court found that there was a duty of procedural fairness. So that's a pretty big win for unions in the federal public sector. We have to see how it's going to play out in practice. And I've also got here some mention about PAPSO, but I did this before they settled their strike. There you go. But you might have heard this morning on the news that the Foreign Service officers seem to have reached a tentative deal and put an end to their strike situation. But while they were on strike, they created a couple of interesting pieces of jurisprudence for us. The one that I want to mention to you today is the decision of the PSLRB that found that the employer had acted in bad faith. And if you recall, in the case of PAPSO, the minister, Mr. Clement, had said that he agreed to go back to bargaining, or in this case it was go to arbitration, but only if certain preconditions were met and agreed upon beforehand. And one of the most shocking conditions there was that the union would have to agree not to use comparables in terms of wage setting. So for PAPSO, this was one of the most important things that led to the strike, is their argument that their foreign services officers are underpaid relative to colleagues that do similar work, including members of the Institute, members of CAPE. And so Minister Clement wanted the union to agree that that wasn't going to be an issue, and that the arbitrator, the Interest Arbitration Board, couldn't look into those aspects if they were to go into arbitration. So obviously PAPSO refused and filed a complaint with the PSLRB, arguing that that was bad faith. That was upheld. The Labor Board didn't order much, except a declaration, and called the parties to try to resolve this, which, as we see, seems to have led to some positive result for our friends at PAPSO. But nonetheless, declarations of bad faith bargaining are quite rare at the PSLRB, so this is an interesting one to draw on. And The facts seem to be a little bit extreme in that it seemed obvious even to people who don't necessarily follow labor law that the preconditions were quite unreasonable in these circumstances, given the facts that had led them to that point. Last we heard, the government was seeking judicial review of that decision. I don't know if as part of their tentative agreement they may agree to drop that. We'll see what comes of that. It's pending before the federal court at this point. I also want to take a few minutes to tell you, sort of check in with you on a couple of pieces of legislation that we've been following with a lot of interest. C-377, you probably all know by now, is a financial disclosure bill that would ask unions to open up their books and disclose their financial transactions publicly on a searchable database that CRA would run. That bill made its way through the House. It's a private member's bill. If you'll recall, Mr. Hebert, who may hope to be a minister one day, had presented this piece of legislation. It went through the House, 3 readings, and went to committee. There had been quite a few witnesses, including the Canada Labour Congress and some other interveners, that spoke up against this bill. It's majorly flawed. It caused a number of privacy concerns. It's basically a hidden attack on unions. It went to the Senate, and at the Senate something interesting happened. Amendments were proposed to the bill, and before the amendments were reported back to the House of Commons, which is the next step that would normally happen, Prime Minister Harper prorogued Parliament. So the impact of that procedurally at the parliamentary level is that the bill, when the House comes back and the Senate comes back for prorogation, goes back to the Senate as if it had never been read at second reading in the Senate. So that means that there is some doubt as to whether the amendments that were being proposed, which were generally friendly to the union's position, and were trying to sort of make a point to the government that this was an extremely flawed piece of legislation. There's some question as to whether those amendments will come back up again. We all know sort of the situation at the Senate that led up to the prorogation. So there's some question from a political perspective whether the Senate will be, quote unquote, whipped back into shape on Bill C-377. But there's still that opportunity for the bill to come back to the House of Commons with amendments. And then it gets interesting because the House would have the option of accepting these amendments or not. If they don't, they could send it back. They could play ping pong for a while with this bill, or the House could at some point just decide to adopt it regardless of the Senate's proposed amendments. So this is an interesting one to watch when Parliament resumes in mid-October. C-525 is another private member's bill. You may not have heard about this one. It was put forward in June, and it aims at changing the rules around certification and decertification. So it would make it more difficult from a statistical perspective to certify members, because now a union wanting to certify needs a majority of the votes cast. This piece of legislation would provide that you need a majority of all members eligible to vote. So if you don't show up to vote, it's kind of like a no vote. So it would make it harder, and then it would make it easier for people to seek to have a union decertified. Again, changing some of the percentages and how the votes are computed. So this would apply to unions under the Public Service Labor Relations Act. So it would directly affect the Institute in the context of a certification drive or a decertification. That was only introduced in June. Nothing's happened to it. And after prorogation, it picks up where it left off, which is waiting to be debated at second reading. Not too sure whether this bill has the political blessing that C-377 seemed to have. It's been a lot quieter from the government front benches on this bill as opposed to C-377. So it may be that this bill will just slowly dwindle and perhaps not move ahead very quickly. That's certainly the hope. So back in October, when the House resumes, we can keep watching what happens to those pieces of legislation. The last item that I want to give you a heads up on is a case called Bernard. Ms. Bernard is a RAN member, and she took issue with an agreement that the Institute and other bargaining agents had reached with various employers, including the Treasury Board, that called for the employer to provide home contact information to the union of its members. The employer initially took the view that it wouldn't provide this home contact info, work info was sufficient. The union back in 2007 brought an unfair labor practice complaint alleging that the employer had an obligation to provide this home contact information to allow the union to do its work fully. That eventually settled, and the labor board reviewed the agreement between the parties and turned that agreement into a consent order of the labor board. Ms. Bernard took issue with that and alleged that it was a violation of her privacy rights, initially, of her privacy rights, to have the employer provide this information to a union which she voluntarily chose not to sign up with. We happen to be that union in this case. So she went back to the labor board, she went to the federal court and asked for judicial review of the labor board's consent order. The federal court said, well, you know, there are some privacy questions that the board could have done a better job at inquiring into. So here's a list of questions, labor board, that I want you to go back and answer. And if you need to amend this consent order in answering those, do that. So it sent it back to the labor board slightly amended the order. And then Ms. Bernard went back to the federal court of appeal on judicial review, arguing that she had, when it was sent back to the labor board, she tried to raise charter and constitutional issues. And the labor board had said no. The federal court of appeal sent down some pretty clear directions to me to answer these questions, and that's all I'm going to do. I'm not going to deal with these new issues. So she went to the federal court of appeal on that. She was unsuccessful. She then sought leave to appeal to the Supreme Court of Canada, and as unlikely as she self-represented all along, she did get leave to appeal to the Supreme Court of Canada. And the issues now before the Supreme Court of Canada are a lot broader than they were back in 2007. And now she's raised the issue of whether providing the information, the employer providing the information to the union, constitutes a violation of her freedom not to associate. So there's a lot of case law at the Supreme Court around the freedom of association over the past years, but the issue of the freedom not to associate dates back to quite a few years ago in a case called Levine, and it had sort of been set down quietly, and then the Supreme Court had agreed that, you know, you could force, quote-unquote, force RAN members to pay dues even if they weren't card-holding members, and that that money could be used for the benefit of negotiating collective agreements and everything else that the union had as its objectives. Since Levine, that issues people like Merit Canada and people who want to see the RAN formula go away have tried to stir up this issue. And so Ms. Bernard has garnered a lot of interest in her case by some of these associations. So this issue, which was ultimately settled by the parties who brought it to the Labor Board in 1997, is now headed to the Supreme Court on November 4th. There are a total of 11 or 12 interveners now on both sides of the story. The Institute and the Government of Canada, for once, are on the same side of this issue, arguing that the consent order providing for the exchange of information is perfectly legal under the Privacy Act, under the Labor Relations Act. It's not a violation of the Charter, but you have Ms. Bernard, who has garnered some support through people like Merit Canada, Canadian Association of Counsel for Employers. The Privacy Commission is stepping in. As I say, there are now 11 or 12. The PSLRB is stepping in as an intervener now. So this case is really being watched by the labor community. It's really a surprising issue to have at the Supreme Court. The basic issue of whether the information should have been shared or not is pretty much trite law. It's been settled for years. There's case law in many jurisdictions saying that a union is entitled to that home contact info and that the employer has a duty to provide it. So it has taken on proportions that nobody ever anticipated back in 1997 when we tried to settle this amicably with the Treasury Board. So keep an eye on that. It's heard November 4th. Again, the decision is not likely to be issued before months down the road from that hearing. So it'll be an interesting one. If you're around and want to come into the Supreme Court, it's going to be a public hearing, so you're welcome to come in. Those are the issues that I wanted to flag for you today that are sort of highlights, but I'm open to any questions if folks have time and want some discussion on anything else.
At the back, Ian. One second, just wait for your mic. Please do the mic. Just hang on one second, just get your mic on so we can have translation. What? There you go. Mic's on. You're good to go.
The Institute's current disciplinary policy, in a nutshell, is if a member has concern, it's submitted to the Executive Committee. The Executive Committee makes a determination as to whether or not the complaint has merit, and the Executive Committee also makes the decision as to discipline. The problem is that when an individual files an appeal on that, the Executive Committee gets to hear an appeal on their own decision. And I believe at last year's AGM, PIPSC AGM, that the dispute resolution and discipline policy was going to be looked into to review this type of what I consider to be totally inappropriate behavior for someone to hear an appeal on their own decision. So I'm just wondering how we're moving along to correct this, please.
There is a modification of the dispute resolution and discipline policy that's coming to the floor of this coming AGM in November. The proposed framework has been is supported by the board, so the board agreed to sponsor the resolutions leading to that. The advisory council had an opportunity to hear about the framework at their last meeting, and essentially it's a complete revamping of the dispute resolution and discipline policy that's going to be proposed that would take the executive committee and the board of directors out of the decision-making process in terms of disciplinary issues, and would see it replaced by what's being called as a panel of peers that would be drawn from a roster of probably 9 members across the country that would be trained and oversee the disciplinary process. The piece about investigations being required for discipline will remain, but how those investigations are considered and where the decisions come from would be completely modified from what we have today.
Well, that seems to be moving the right direction. My second question is, recently the Federal Court of Appeal on or about May 13, 2013 issued a decision to the effect that PIPS was in contempt of court and fined $250,000. And given that a dues increase may be on the table and is on the table, I was wondering what is the lesson learned by PIPS to ensure this type of behavior does not happen in the future?
So the decision you're referring to is called PSAC, and it is publicly available. It's actually a lot more recent than May 13, the Court of Appeal decision. I don't have the exact date on me, but it's more
May
like
13.
No, it was last week or the week before. It was heard in May at Vancouver, and less than 2 weeks ago, the Court of Appeal rendered its decision. So what happened in PSAC is that the Labour Board had made a finding, and this is a case that, again, spans several years, so I'll try to address it briefly, had made a finding and had made certain orders against the Institute in relation to a policy that's called a policy on members and complaints to outside bodies. And one of the orders was reinstatement of Ms. Bremsack. Between the order of reinstatement and her reinstatement, there were other events that occurred leading to, well, if you go into the decision, it's going to be public, so leading to the disciplinary suspension of Ms. Bremsack for other reasons that made her reinstatement impossible. Ms. Bremsack argued that the Institute was in contempt of court because it failed to reinstate her and failed to post the posting as ordered. The federal court ordered a fine of $400,000 against the Institute in December of last year. The Institute appealed that decision to the Court of Appeal and was granted that appeal. The fine was reduced to $250,000. If you want to go read the Bremsack decisions, because there are several of them, you'll see that the issue of contempt and how we got to that point is complex, is lengthy, and certainly I can assure you that at the Board of Directors level, there have been several discussions around lessons learned and steps that can be taken in the future to avoid such issues. And I'm not really at liberty to have that discussion. Those discussions happen in closed session generally, but I do invite you to have the discussion with your elected officials. It was not, this was the second case under Section 188 of the PSLRA, which is a new section since 2005. It's the first time that a union was faced with dealing with allegations that members had been disciplined for a discriminatory purpose, and there was contradictory case law existing at that time that didn't make the choices as obvious as they may seem today in hindsight. So there's certainly been a lot of development in the case law in that area, and a lot of changes internally in terms of perhaps how we deal with conflict moving forward. That certainly informed the framework that's going to be proposed in November.
Well, I hope there was a lesson learned there, because it's certainly frustrating to see my dues and that of my members being used to engage in such activity with such negative results. And it's not only the $250,000 fine, but it's all the legal costs we apply to it. Thank you.
Thanks. Can't remember who was first, so we're going to go ladies first. That's okay.
Isabel, I'm Karen Micarelli with the NCR subgroup, and I want to ask you a question about Bill 377. Early this summer, QASA and ODLC and PIPS and PSAC got together. We were all very concerned about Bill 377. So PIPS and QASA wrote a letter to every single senator about Bill 377 and how flawed it was and how it would hurt us. We got letters back from the senators saying yes, they agreed, and then they put it to vote. And it looked to me, it seemed to me that it was a very healthy vote for us in the no, it's not an acceptable bill. And now you're saying that this could possibly be brought back in as if the bill was never touched, never talked about, never voted on. And my question to you is really, is Harper determined to get us with